Audio mic check. All right, testing microphone 1. Number 2. Number 3. Microphone 4. Microphone 5. Microphone 6. And number 7.
Water? You guys have a picture of water by any chance?
Yes, we do.
I don't mind grabbing into this couple of it.
Got some right here for you.
Practically squeezed.
Oh, yeah, that'd be great. Thanks.
I was guessing. Solo cups.
This isn't yesterday's water, is it?
No.
Can I get another cup?
I would use that to actually go over here.
These could be used after for beer pong.
Don't drink too much. Before it's over.
go to law school?
Just a
Uh,
heads up.
nowhere at Widener. I fancied myself going into health law.
Podium check, one more time.
Health law program.
Yeah. I went to Portland, I got into Suffolk, but at the time, I really didn't have a lot of experience with city life. It was already intimidating enough to go to law school.
Justice 1, check.
Yeah.
Justice 2, check.
You went right after undergrad?
I actually took a year off, so I was in pre-law.
Justice 3,
My
check.
advisor, I think,
Justice
I think
4,
law
check.
school was the right idea for me, so never, I should have known.
Justice 5, check.
I had to take the LSAT. So by the time I
Justice
realized
6,
that,
check.
it was too late.
Yeah.
So-
Justice 7, check.
So what was your total number of years in prosecution?
22?
Yeah. This is my 23rd year, so.
persons having anything to do before the Honorable Justices of the Supreme Judicial Court, sitting at the Law Court at Bedford, within and from the state of Maine, may come forth and declare, and they shall be heard.
Good morning, you can be seated. The matter before the court is Knox 24-164, State of Maine versus Hasahn Carter. I see counsel are present. We are being streamed on the web, both by audio and video. If counsel would identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning, Michele from Thistle, Weaver, and Morris for Hasahn Carter.
Good morning, Christopher Fernald, Assistant District Attorney for Knox County, representing the state of Maine.
Thank you. And Attorney King, if you're ready to proceed, we're happy to hear your argument this morning.
Good morning, and may it please the court. The main issue before the court today is whether an unconstitutional search occurred when the police engaged an emergency function on the cell phone found at the Haskins residence to call 911 dispatch in order to obtain the associated phone number, and also performed online searches with that phone prior to getting a warrant. It's important to note what's not before the court today. 1, inevitable discovery, and 2, abandonment. The motion judge did not address inevitable discovery in the order denying the motion to suppress. The court determined that there was insufficient evidence of abandonment. The state declared in its brief that even if this court determines that a search occurred and there was an expectation of privacy in the phone, that inevitable discovery and abandonment should be applied. The state, however, in no way developed that argument, nor did it cite any cases in support thereof. Consequently, the state has waived these claims on appeal, regardless of whether they were raised below. The Fourth Amendment to the United States Constitution protects the right of people to be secure in their persons, houses, papers, and effects. The effects need not be in one's house. While there's a dearth of cases that address the specific issue here, there are 2 cases that I would suggest are particularly helpful. The first is Riley v. California. And while the facts of that case are different from the facts of this case, Riley involved the search incident to arrest, and there was no dispute that there was, in fact, a search. The court's rationale is instructive on 2 fronts. First, the amount of information that can be gleaned, even from a limited access to the private information that's on a smartphone, sets it apart from any other type of search. And secondly, as a result of that, when in doubt, get a warrant. The second case is the United States v. Gomez, also a search incident to an arrest case. The court said there, and I quote, "As the weight of authority agrees that accessing a cell phone's call log or text message folder is considered a search for the Fourth Amendment purposes, it would logically flow that an individual also has a reasonable expectation of privacy with respect to operational functions on that cell phone, such as making calls or exchanging text messages." When Detective Murray engaged the 911 function on the password-protected phone, it was a search because he violated a subjective expectation of privacy that society would recognize as reasonable. The very reason for employing a password on a cell phone is to keep the information not readily apparent on the screen private. The cell phone number of this phone was not available on the screen, which is why Detective Murray had to call 911 in order to find it. In addition, Detective Murray performed online searches with the phone prior to obtaining a warrant. In State v. Casey, the Florida Court of Appeals discussed at length the reasonable expectations of privacy involved in password-protected phones, and determined that even where a cell phone is abandoned, if it is password-protected, a warrant must be obtained. In that case, the information that was gleaned from a search of that phone was merely the defendant's identity, as in this case. In this case, the lower court determined that...
As you probably know, there is a plethora of authority that holds that a person has no legitimate expectation of privacy and information they voluntarily turn over to third persons. The idea being that That information is out there already. It doesn't have the same level of protection. Your response to those cases that have held to the contrary of the cases you've cited here?
Yes, Your Honor.
Is the reasoning flawed in some way?
The Hill case that was cited by the lower court and by the state's counsel talked about that a bit, and some of those cases are quite distinguishable. And I would suggest here that the distinguishing factor is that the defendant did not, in this case, place a call that voluntarily put his information out there, such as one of the cases cited in the Hill case, the Stephenson case talked about a landline where the caller was the defendant who made the call and voluntarily put that information out there. In this case, it wasn't the defendant who voluntarily put the information out there, it was the police officer who made the call.
Isn't it more so much not this one call, but in general, that by virtue of having a phone, there are many people who have my phone number because I call and they see my phone number. I hate to think how many people have my phone number.
Understood, Your Honor, but the police didn't have that number. It was even though I may have, or my client may have
They
put that
didn't,
out.
but I mean, doesn't that go to the expectation of privacy issue in the number itself? In other words, that by just the very nature of a phone means that you are sending your number, the way technology works, you are essentially sending your phone number to people routinely. Anyone who has a cell phone does that.
Well, agreed, Your Honor, but when you have the specific phone in your hand, when the police have their phone in their hand and it's a password-protected phone, I would suggest to you that that piece of evidence, the cell phone number that's in that phone, again, is protected, and there's an expectation that it's private because, again, it's
But
not
why
on
is
the
it
screen.
protected? You say password protected, but he didn't have to know the password, the officer, in order to press the emergency button. So it has nothing to do with the password-protected portion of any confidential information, does it?
Well, I disagree, Your Honor, because the police officer didn't get the phone number by just simply pressing one button. He had to engage a 911 operator who then gave him the information.
But
So it wasn't-
he didn't need to know the password, correct?
He didn't need to know the password to place the call, correct, but he didn't press one button and my client's phone number came up.
But
That would be
you-
a whole different scenario.
Is pressing the button the significant event here, or is it dialing the 911 number?
My understanding is, from the way that the testimony came out at the motion hearing was, and my also personal experience is, you can slide over an emergency function on the phone, and it will dial 911 for
Right.
you. You don't see the actual keypad, and you don't have the ability to dial 911.
But what's the significant event? Didn't he first have to press a button to have that appear on the screen?
He had to press a button for the emergency function to appear on the screen, but the cell phone number itself did not appear on the screen.
Understood, but you said earlier, you referenced operational function. Is that the operational function you're talking about, pressing the button to make that screen appear?
No, Your Honor, it's actually placing the
Placing the
call
call,
and
okay.
speaking with somebody, much as when a police officer has a cell phone in their possession and they answer an incoming call and pretend to be the defendant and glean information and then send text messages out,
But
such as in the
can I-
Gomez case.
Can I just take it, the perspective you're leading off with is that the police had no access to that number until they dialed the emergency number. But taking the chief's example before, she talks to a lot of people on the phone, so her number's out there. So if somebody wanted to get the chief's number, they could call me and say, do you have the number for the chief? And I'd say, yep, and I'd give you the number, and they would have it there.
That easily?
Well,
To anyone?
not in this instance.
maybe you're not that close, Your Honor.
Specifically here. You'd have to take another route. But the point I'm making here is that the information is out there in a way that doesn't, you're focusing down, the police don't have it, but it's out there. Are we talking about the people involved or the data that's no longer private?
Well, a couple of things, Your Honor. I would say that the police could have done that investigation, but they didn't. Instead, they chose to search my client's phone. And the fact, again, I
To be
go
clear, they
back-
didn't do the full search until they had a warrant.
Right, which they could have done prior to calling 911. The better way, and I think the United States Supreme Court says in Riley, get a warrant. 2 days later, they did get a warrant. All they needed to do...
And the warrant, the affidavit, doesn't, to support the warrant, doesn't say anything about that what you call a search. It just says there's this phone that we found and an unknown owner, and so at the time that they got the search warrant, they weren't referencing that allegedly illegal search. So how does that affect, what are we excluding?
How does it affect the validity of the warrant?
Well, that the police decided to, leave off that portion of it doesn't, I mean, that issue was addressed by the motion to suppress and was addressed by the judge.
But the question,
So-
what is the consequence? Suppose we think that the search was unlawful or violation of the Fourth Amendment. What is the consequence of that? Is there any evidence that was derived from this 911 call?
Oh, most certainly. The
What
evidence.
was it?
Yeah, the evidence that was derived from this 911 call was first the defendant's phone number. And then they used the defendant's phone number to to contact Verizon and
Let me
get.
rephrase it. Is there any evidence that was only derived from the search? And because there was a search warrant 2 days later, right?
Correct.
And then they're in the entire phone. As Justice Connor said, the warrant affidavit doesn't reference this 911 call. And once they're in the phone, they have the phone number, they have a plethora of other information. So what's the consequence of this search?
Well, they wouldn't have the phone number. They wouldn't be able to go any further if they didn't have the phone number. So they couldn't.
You can't get your own phone number from your phone?
I'm sorry?
You're saying the police would not have been able to get his own phone number from the search of the phone?
They didn't know who the defendant was. They got the phone number from calling
but-
911.
I understand, but my question to you is a little different. When they searched the phone, let's say they hadn't done that, but they got the warrant to search the phone, are you saying they would have had no way of identifying at that point what the phone number was that was associated with the phone?
Oh, once they got the warrant, all of that information would have
Okay.
been readily available to them. But that's the inevitable discovery argument.
Well, it's a little different, though. I mean, what's the remedy if because they searched the phone pursuant to a warrant, what's the remedy if the initial 911 was illegal?
Well, the remedy is to remand it back, I suppose, to have the judge address some of the issues that weren't addressed, because the lower court in this case specifically didn't talk about inevitable discovery or whether or not that the warrant itself provided the information. The lower court focused on whether or not it was a search to place that 911 call and whether or not there was a crime scene exception. So the lower court didn't at all address the issue that you now raise.
Okay, thank you.
Thank you.
Attorney Fernald?
Good morning again. May it please the court. There are two issues on appeal before this court. The first issue is whether the lower court erred in denying a motion to suppress, and the second issue is whether the lower court erred in denying a renewed motion in limine. Starting first with the motion to suppress, the appellant pointed out correctly the standard of review. The facts regarding the motion to suppress are largely not in dispute, so really the focus of this court would be a de novo review regarding the legal conclusion that the lower court made. Under the state constitution...
Oh, it's green. You said the facts are not in dispute. One of the findings of the court was that it wasn't abandoned. So is that a fact conclusion, or is it a legal conclusion, or are you conceding that it wasn't abandoned? What's your position on abandonment?
Well, that was certainly something that was argued at the lower court, but that was not the focus of the state's argument. I would think that that would be a legal conclusion, and when I say that the facts are not in dispute, it would be the lower court's factual determinations And I think that one of the justices asked a question about the facts. And again, the determination was that the cell phone in question was located on a stairway in the home that was the location of the alleged crime. The cell phone was password protected. Detective Murray pushed the emergency button on the phone's lock screen to dial 911, and as a result was able to obtain the phone number on the phone. The phone in question was not found at the defendant's home, on his person, or even a vehicle where he had been lawfully present. There is no allegation of a physical intrusion or trespass, and the phone was found in the home of an apparent crime victim where the defendant had no right to be. So the state's real argument here is that there was no search that was done of the phone by the law enforcement's action. The law enforcement's action was certainly reasonable, and even if there was a search, then that would not be an expectation of privacy in someone's phone number, which is easily located as suggested.
Can I challenge you on that? You say that the phone number is easily accessible. What happened here, if I had someone's cell phone, I can't call the emergency number and say, "Hi, I'm Joe Jones. What number is coming through on this?" It is unique to law enforcement that they have the ability to speak to the 911 person on the other line and say, "Hi, I'm Detective Jones. What number did I just call?" So in that sense, the number isn't out there, but law enforcement has this corridor that allows them to get to it. Does that take it out of this argument that phone numbers are out there in the public sector?
Well, I wouldn't say that, just because, again, even though it may not be easily accessible to everyone in the public who may pick up a phone, phone numbers are shared by third parties. Case law talks about that. And individuals share their phone number with third parties, knowing that that may end up ultimately being shared with law enforcement.
Can I ask you a question, a little bit off topic and perhaps beyond the scope here, but I get the sense that this technique is being used out there by law enforcement across the country, that if they get a phone, they just dial the emergency number, which comes up automatically, and they have a direct conduit to the phone number, which has nothing to do with, social networking, anything else. Do you know whether it's a widespread practice that law enforcement across the state, across the country, if they get their hands on a phone, they got the phone number because of their status?
Well, certainly the Ohio case that the state cited talks about it being more prevalent now. As far as in the state of Maine, I wouldn't say that it's widespread, because if that were the case, I would expect that the court would have seen this issue come up before, and this is a case of first impression. My own personal experience as being a prosecutor for more than 22 years is this is the first time that I've seen this happen. And so even the appellant mentioned that inevitable discovery should not apply, but the state does think that it should apply. Even if this court were to determine ultimately that it was a search, that there is an expectation of privacy, that it should still not be excluded pursuant to inevitable discovery.
Spin that out, please.
Well,
Explain that.
Well, the reason why there wasn't much case law that was cited on the point is because this, from the state's perspective, is a well-settled area of the law. So I didn't feel the need to outline that in my brief. But the fact is that when there was a warrant ultimately that was obtained, and even that was challenged in the lower court. It was upheld by the lower court. And when they executed the warrant, they would have gotten the same information. That is the appellant's phone number.
But do we need, to reach that issue or to decide that issue in your favor, do we need any sort of factual findings from the trial court along the lines of law enforcement would have obtained this warrant regardless of what happened with the 911 call?
I don't believe so, because as one of the justices pointed out earlier, that really wouldn't be something that would be in dispute. I don't even think the appellant was arguing that that information couldn't easily be located once a warrant is executed.
My question's a little bit different. Do we need a finding? Because it's possible sometimes you have an investigation where the police, they find information A that just causes them to look for information B. Do we need a finding that the warrant here was truly independent of this 911 call? In other words, regardless of whether they had found that number or not, they would have sought this warrant. Did the trial court make any finding in that regard?
I don't think the trial court got, or the lower court, it was a different justice as far as the lower court that ruled on the motion to suppress. I don't think they got to the issue of inevitable discovery, but from the state's perspective, to remand it just to make that one factual determination should not be necessary.
Well, it's not really a fact question. as to, you can look at the search warrant affidavit, and it doesn't reference anything to do with the 911 call or even the owner of the phone. So you can look at that and say, well, that looks pretty independent of any pressing of the button to get the 911 call.
That's correct, and then under that theory, you wouldn't even need to get to inevitable discovery.
The suppression judge made an analogy to a dropped phone to blood found at the scene. I'm not sure, meaning in terms of the lack of expectation of privacy in either. And I'm not sure I follow the analogy completely, but this was a lost phone. And I think it's fair to say that when someone loses a phone, they expect other people to try to locate the owner. So was there any expectation of privacy in this phone, I guess is my question.
And the answer would be no, and I would use the analogy, if an individual loses a wallet, it's not unusual for someone to pick that up, to look for an ID, for example, a license, to be able to contact that person to let them know, look, I found your wallet. And if it was turned over to law enforcement, I'm guessing that law enforcement would do the same thing, and that in that situation, it would be reasonable. Again, that's the threshold question that this court or any court has to ask itself under the Fourth Amendment, is was law enforcement's conduct reasonable? And I think the analogy that was used by the lower court, the reason why it was used, and it is because, of course, in this day and age where cell phones are becoming more and more advanced, they have so much more information. It's like individuals are walking around with personal computers. They have a lot of sensitive information, and the analogy is that DNA that could be recovered from blood, obviously it doesn't get much more sensitive than that. The court needs to look at the entire fact pattern from the state's perspective. It's not just that only 911 was called through pushing the emergency button. It's the fact that the phone was found at the scene of a home invasion after there was a struggle between the victim and the suspect. And that in that situation, society would not recognize that there would be an expectation of privacy in that phone being found there and 911 being called.
The court found specifically, or mentioned specifically, that the phone was not abandoned, but then went on to find that there's no expectation of privacy in a device left at a crime scene. Are you aware of any precedent or authority that would support a crime scene exception?
No, and I believe I even indicated that in my brief, that I'm not aware of a crime scene exception. Again, I think you have to look at the entire factual pattern, the context in which it was found. I don't believe that the lower court justice got into much of the rationale as to why he didn't feel that it was abandoned property, or perhaps didn't feel the need to get into that analysis, but it's probably because it was a situation where there was a struggle and then the suspect was fleeing when the phone was left. So that certainly he did not abandon it in that way is again what the argument would be from the other side.
Well, it's also that the phone is found not at the person's home or within the curtilage where there's an expectation of privacy for the containers within the home. It's a house that belongs to someone else who isn't complaining about the search, and I think it's pretty clear that Mr. Carter didn't make any effort to find his phone or call anybody. He fled and he left the phone there. And so when the court is saying there's a crime scene exception, it's also perhaps saying when you flee a crime scene that isn't a place that belongs to you and you expect protection, there is no reasonable expectation of privacy. Whether we call that abandonment or no expectation of privacy, doesn't matter. That's a legal language, isn't it?
I don't think it matters. And again, I think the key question, and all the case law supports this, is was law enforcement's conduct reasonable, and was there an expectation of privacy that was recognized by society? And the case law talks about property being found on a person, in a vehicle, somewhere where they would have some protection. And as I think Your Honor is suggesting, there's just not an expectation of privacy in property you leave behind after there's a home invasion.
Are you aware of any case law that suggests that the activation of the emergency number was not a search in and of itself? In other words, pressing the button and then having law enforcement?
Certainly not in the state of Maine. This is a case of first impression in the state of Maine. And again, the closest fact pattern, the analogy, is the case out of Ohio, State versus Hill, which I cited too extensively. And under that analogy, again, there was no violation of state or federal constitution regarding a search and expectation of privacy.
Would you favor or urge us to adopt a crime scene exception to items left behind at crime scenes as a matter of policy?
That would be favorable to the state, but I'm not necessarily going to urge the court to do that or go down that road.
Okay.
Oh, well, to phrase it differently, would you be amenable to a conclusion that says when someone leaves something that it's owned by them, a murder weapon or something else, a phone, and they leave a scene of a crime in a place that's not belonging to them, you should deem that abandoned property?
Again, as I think Your Honor said earlier, you don't need to necessarily come to that legal conclusion, and the case law already says you don't have an expectation of privacy in items that were you described, and so I would say that the court follow what has already been ruled upon in the past, and again, that's when you come back to the analogy of blood or any sort of bodily fluid that's left at a crime scene that individuals don't have an expectation of privacy for.
What if it was a backpack, a full backpack left behind? I mean, what would the state's position be? I would imagine in that sort of circumstance, law enforcement probably routinely would open that backpack to see what's in it when investigating a crime.
Again, under the other arguments, there'd be no expectation of privacy in that situation. But in that analogy, I think it's closer to when you're looking in a backpack that's looking into a phone to look at the content and the data. And as the court mentioned, law enforcement didn't do that without a warrant. They obtained a warrant before they did that. If there's no other questions, thank you very much.
Attorney King, earlier you said it's not before the court to talk about abandonment or inevitable discovery, but you do agree that we have the ability to affirm on a different legal ground. In other words, if it's fact-dependent, but if it's a legal conclusion, right?
I do, Your Honor, but again, because the lower court didn't address inevitable discovery, it's the prosecution's burden to prove inevitable discovery. And in this case, there was no discussion of that, really. There was no conversation about it.
Well,
And-
but putting that aside, I mean, but don't you agree that they would have, you already said, they would have gotten the phone number off the phone when they searched it under the warrant, right? Which is the only
I agree
information.
that they did get a warrant.
Right. And that having searched the phone at that point, there's no way they wouldn't get the phone number, which is the only information that the officer got from the 911 call.
That's correct.
And that that 911 call and identity of the phone number was not part of the affidavit in support of the warrant.
Correct.
And that when we said the search of the phone, which is what you're really concerned, I mean, what you want is not to have the search of the phone information come in.
Of course.
That we would have to find that warrant invalid, wouldn't we?
Well, I think there would have to be some factual findings.
Or the lower court would have had to find the warrant invalid.
Correct.
But can't we
There was
just
no
look at the
factual findings
warrant?
on that. There were no factual findings, and that's the problem.
I
That's not the
understand.
job of this court.
But the validity of the warrant, isn't that judged on the face of it? Can't we look at it?
Not where the state has a burden to prove inevitable discovery. It's not a
What's the
situation.
What's the fact that the trial court would have to find?
Well, the trial court would have to find, I suppose, the circumstances of obtaining the warrant, the circumstances of how the information within the affidavit was tied to
But is that part of a challenge to a warrant? I mean, unless it's bad faith, I suppose, but.
Well, I mean, I guess a bad faith argument could have been made. I mean, but
But was that made by the defendant below?
it was not made by the defendant below, but neither was there a discussion of inevitable discovery.
Does there need to be a finding that the police would have sought that warrant regardless of the results of the 911 call?
I believe there does. I mean, it may not have been included in the affidavit, but that's how they got there. They got there only because they got the phone number and they got the defendant's information.
What about the abandoned property concept, which the suppression court did touch on, analogizing the dropped phone to blood at a crime scene? But when someone drops a phone or leaves a vehicle on the highway and the phone is turned into the police or the police come to the vehicle, what do we expect the police to do?
We expect the police to get a warrant. That's what the United States Supreme Court requires. If you find
Not to
something...
find out who owns the seemingly abandoned phone?
Right, but again, the abandonment issue needs to be supported by law and facts. And in this case, the lower court specifically said there was insufficient facts of abandonment. So this court can't, make up facts to find that there's suddenly abandonment. That determination has been made. And when you're analogizing a drop of blood at a crime scene to a phone is significantly different. I would argue that a drop of blood doesn't even fall under the Fourth Amendment. It's not a person, it's not an effect, it's not a piece of paper. It's something that's outside of someone's body. It doesn't even come under the rubric of the Fourth Amendment.
Thank you, counsel.
Thank you.
As is our usual practice, we'll be taking the matter under advisement, issuing a written decision in due course. Thank you, counsel, for the interesting argument.
All rise. We are in recess.